Marlon, attorneys work on time and you've waited long, so I really appreciate it. But yeah, I think we're going to end off on a high with incredible value that you can share with our audience. You've been spending some serious amount of time in the High Court and also the Supreme Court of Appeal last year on a case called Els versus Venter. And that will definitely change the outcome of this, have definitely changed the way our clients will review leases and also how they onboard new landlords or investors on their portfolio. So give us the crux of this case. And I think,
Sure.
well done. It seems like you won. But give us the crux of the case and also the impact to our clients going forward.
Thanks, Johann, and thanks WeConnectU for joining me to this amazing platform. I wouldn't say we won. We actually didn't win. We partly won, but the question is whether it's a win for the industry. You know, I've always maintained educating rental property agents is the most important thing, and I don't believe, just put it out there, that enough is done to educate rental property practitioners, as they're now called. In very simple terms, the case of Els versus Venter changed South African law with regards to the rental property arena, residential more than commercial. So it's the residential rental property arena that has now been changed. And I've got 1,000 pages of notes I could send out. In fact, what I'm going to do is I'm going to make available a list of questions that rental property practitioners need to ask their landlords pursuant to this case. And what is this case about? Very simply, there was a lease agreement where a tenant of ours, a very well-to-do tenant, an economic officer of one of the top listed companies in the country, who agreed that the landlord could give him 3 months' notice at any time to leave the property. And obviously, you think of the Consumer Protection Act, and the Consumer Protection Act is quite clear. The only way to end a lease agreement with a natural person for a fixed-term lease, and rental agents who use the WeConnectU system would know this, is to give 20 business days notice if they've breached. Our client, the tenant in this instance, which is interesting because we usually represent landlords and rental agencies, is that the tenant never breached. But yet, the agency who was selling the property said, no, you've got to leave. You agreed to leave. The property is being sold. And I said, no, don't go anywhere because you haven't breached. They took us to the High Court of the Western Cape, urgently saying he must leave by this date. A purchaser wants to move in, free and vacant occupation. He agreed to leave. He hasn't left. He's not going to leave. And we lost. But because it was such an important point, and the important point was, and it impacts the industry, as I'll explain very quickly, in that usually it's about, is the tenant a consumer in terms of the Consumer Protection Act? Is it a natural person? Is it a fixed term lease? We lost, but the High Court said it's got such importance that it must go to the Supreme Court of Appeal, which is the highest court of the land for any matters that are being appealed. And when the Supreme Court of Appeal makes a ruling, it becomes South African law. It's as if the government has legislated it. And what they said is it's no longer a question of whether a tenant is a consumer. The question is the supplier, is the landlord a supplier in terms of the Act? Did the landlord lease the property in the ordinary course of business? And why is that so important? Because firstly, the court said we lose because even though it was a natural person who's never breached, he agreed that the landlord could end the lease on notice and he must leave so the new purchaser could move in. There was no breach of the CPA. There was no 20 business days notice. There was nothing that is the normal role of a rental property practitioner. If you look at it logically, anyone who's managing a rental asset on behalf of a landlord, if it's a natural person tenant and it's a natural person lease, there's got to be 20 business days notice to remedy a breach. There's 7 days in order to pay before we can sue you. There's 80 to 40 business days that we send you a letter asking if you'd like to renew the lease and what the renewed commission would be. Based on the law now, if it is not in your ordinary course of business, in other words, if it's a once-off or a part-time thing, there is no CPA, which means rental property practitioners do not have to worry about 20 business day letters. Tenants are not allowed to terminate on 20 business days notice, subject to a penalty. So the very mandate that a rental property practitioner must sign with their landlord needs to ask them a few questions. It needs to ask, is this what you do for a living? Is this your main income? How many properties have you got? Have you been leasing it continuously? There's about 15, 20 questions which every single rental property practitioner must now ask their landlord. And based on those answers, Johann, they can then say, this is the mandate that you sign. Tenant, this is the lease that you must sign. And you mustn't forget, A landlord is the consumer of a rental property practitioner. A tenant is the consumer of the landlord supplier. The very nature of how you manage your books of account, the very nature of your letters and your notices being sent out, the very way you use the WeconnectU system is going to depend on who your landlord is. So it's no longer a tenant-centric argument, it's a landlord-centric argument. And there's going to be exposure now. I'm a landlord. I tell the rental property practitioner, oh, it's not my ordinary course of business. I've got 20 properties, but I don't lease them continuously. You go ahead and you present a non-CPA lease to the tenant, relying on what the landlord told you. Next thing, the tenant wants to get out of the lease, and the landlord says, well, you can't. And the rental property practitioner who acts on the instructions of the landlord says, no, you can't. And then suddenly the rental property practitioner is exposed. Did he ask the correct questions? Is it the correct lease? Was I allowed to give 2 months notice to leave, even though there was no breach? So Else versus Spenter, and obviously the case is very important to read, has redefined for the rental property industry as to how rental property practitioners need to handle their landlords, how landlords need to handle their tenants, what rights tenants have, and the loss that tenants have lost now, the rights that they've lost, just because the landlord may or may not be a supplier in the ordinary course of business in terms of South African law. And that's why we are redefining mandates. We are amending leases. We are putting indemnity clauses in mandates. We are putting questions in the mandates that landlords need to complete to protect the rental property practitioner who gets the authority to procure a tenant or to manage a property or to do both.
Marlon, you've got the ability to just summarize thousands of legal documents in it was a couple of minutes. So well done. I know if I open up the Q&A now, we'll probably sit here for an hour just unpacking all the detail about this case and the real implication for our clients. But I want to challenge you, or not challenge you, ask you, this 15 questions, let's work together to make that available to every single member that we're sitting in today. I think that'll be incredibly valuable. And obviously, if you guys would like to consult anybody on the changing of leases, you obviously know who to speak to. Marlon, sorry for the delay of the overtime that we went to. Thank you for your time. Well done on your part in this case and changing South African law. And yeah, we appreciate your time.